Welcome back. I hope you all enjoyed taking a break and are ready for Who is the Client? Ethical Issues in Corporate Formation, Acquisitions, and Other Transactions. For those that are just now joining us, my name is Bryden DeWitt, and I am a partner in our Employee Benefits section. I focus my practice on all areas of employee benefits law, including qualified retirement plans, health and welfare benefit plans, ERISA fiduciary duties, and benefits issues arising in mergers and acquisitions. Joining us now is my colleague Patrick Haynes. Patrick is a partner in our litigation section and serves as co chair of the White Collar and Investigations team. He focuses his practice on handling all manner of disputes that arise from business competition and regulation, which has included a broad base of civil and criminal litigation at both the trial and appellate levels. Patrick has substantial experience conducting investigations both in the United States and overseas. He is co chair of the ABA Criminal Justice Section's International White Collar Crime Committee and co editor of an international guide to corporate internal investigations published by the ABA. Patrick advises clients, general counsel, C suite management, and boards of directors on their highest profile crisis and litigation matters. Of more immediate focus for today's session, Patrick serves as deputy counsel and chief ethics counsel to the law firm, and he is a member of the Virginia State Bar Standing Committee on Legal Ethics, which was established to issue advisory opinions interpreting and applying the rules of professional conduct. Now over to you, Patrick.
Thanks for that introduction. Appreciate it, Bryden, and I appreciate everyone coming back in for your ethics hour right after the lunch hour. I'll do my best to make it punchy and get you through what I think is an interesting and timely topic, which it again involves primarily conflict of interest issues, but other ethical issues that arise in corporate entity formation, acquisition, and due diligence. The presentation today will cover really three areas of ethics, legal ethics, professional representation in this context. First is conflicts of interest. The second will involve attorney-client privilege issues in the context of corporate formation, dissolution, or not dissolution, but corporate formation and then acquisition, selling an entity and acquiring an entity. And the third area will be candor to others, people other than the clients, but others involved in the acquisition. So we'll go ahead and start with where it starts, conflicts of interest and entity formation. Can you go to the next screen, please? Thank you. Okay, so the background here is, again, in the representation of a forming entity. In the course of their practice, many lawyers, as you know from your own practice, help people to form a business, form legal entities through which the people, we'll call them entrepreneurs for this purpose, and some of the commentators use that terminology to describe the constituents here, through which these entrepreneurs, if you will conduct new business ventures. This entity serves as the legal structure for the business venture. It might be a partnership, might be an LLC, it might be a LLC, or one of the several different types of corporations. When those entrepreneurs first contact lawyers, they often have the business venture in mind, but they are agnostic about the legal entity through which to conduct the business. At the end of the process, of course, what they're hoping, and the attorney helping them is hoping, is that the end product of that effort will be a legally recognized entity with an owner or co-owners, some financial status, a set of people who can act on behalf of the entity, that there will be rules for how it will operate, and ultimately perhaps a lawyer for the entity itself. So part of that formation process, and what makes the conflicts analysis interesting, is part of that formation process occurs before the entity even exists. And part of it takes place after it exists. So the scenario that we have up on the screen, the author of this hypothetical is a legal ethics expert, Stephen Gillers. I'll give him full credit, who uses this as the starting point for analyzing these issues regarding conflicts in the formation of this new entity. All right, so the scenario begins: a magician, a baker, and a puppeteer walk into your office. I know, sounds like the beginning of a bad joke. The magician, a baker, and the puppeteer walk into your office and tell you they want to start a business that will run birthday parties for children. The magician is going to put up most of the money. The baker has extensive experience with children's birthday parties. And the puppeteer, who has a well-earned MBA degree from Duke University, will manage this thriving business. They ask you to help them form a company, including advising them on such issues as choice of entity and allocation of ownership and control. Can you do that as an attorney? So this is all to set up in Giller's hypothetical the question that arises immediately is whether conflicts of interest prevent that lawyer from representing all three founders. And if they do, the lawyer presumably will represent just one of them. That can go either way. Fundamental first question that the lawyer has to ask himself here is, whom will I represent? Can you go to the next screen, please? So as to the first part of that question, may you as an attorney represent all three? Well, this starts with in the rules, and I have the Virginia rule up here, but essentially the same in the jurisdictions that we're talking about, is Rule 1.7a of the Rules of Professional Conduct, which provides that a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if the representation of one client will be directly adverse to another client, or that there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client or to a third person. And those are the applicable parts for our analysis. Comment 27 of the rule speaks more directly to explaining the application of this rule in our setting. Comment 27 reads that a lawyer may not represent multiple parties to a negotiation, which is what we have in our scenario, whose interests are fundamentally antagonistic to each other. But common representation is permissible where the clients are generally aligned in interest, even though there is some difference of interest among them. So we're in a land under the rules of ethics where it's possibly permissible if we can conclude that they are generally aligned in interest. But that's just the beginning of the analysis that we have to go through. Can you go to the next screen? The things that we have to consider in analyzing these interests of the multiple constituencies in this formation setting is how their interests may differ. When they walk in the door, by the way, they start off, these entrepreneurs or organizers in other terminology, as prospective clients. And there's a rule in the Rules of Professional Conduct, Rule 1.18, regarding the duties that are automatically owed to prospective clients who you communicate with about the possibility of representing them. So when our entrepreneurs walked in the door, they automatically become prospective clients while the lawyer determines whether he's going to represent one or more of those people as clients. And under Rule 1.18, the lawyer automatically owes a duty of confidentiality that remains even if the lawyer declines to represent some part of them. The second consideration is that you may have people who are co-owners or who propose to be co-owners. You may have a situation where prospective investors are either in the room, or you know that eventually they may be involved in this entity. So there may be interests that are involved there that we have to think about, of people who aren't even in the room yet, but you know that they may be down the road. The other constituents that you have to think about are the potential directors, officers, and key employees of this entity. So it may be as simple as the one that seems to be set up in the hypothetical, in terms of that the three operators and the three owners were presumably in the room to start with and are going to remain those having those roles. But there may be others in a different situation that we also have to contemplate could be involved. Now, the subject of this section of the presentation is not only about formation, but also about acquisition, merger, and due diligence. So let's also think about this, or look ahead to thinking about this issue of multiple constituencies, thinking about, I'm sorry, the next screen. Can we go to the next slide, please? Thinking about the client selling itself, and that also is going to have multiple constituencies down the road. Multiple owners in a company can mean differing economic interests in the outcome of a sale transaction. You may have owners and employees who will be involved in the business post-transaction, and some who will not be involved in the business post-transaction. You may also have owners with third parties who own a significant asset related to the business, such as owning real estate that's occupied by the business, and maybe they will continue to own the real estate that's occupied by the business after a sale. So all of this is to say that these multiple constituencies may have multiple interests that are different, that have to be considered in determining who to represent. Can you go to the next screen, please? Okay, so we're starting with this analysis of who we're going to represent in our scenario for the formation of the business. Frequently, the question comes in that situation, well, why can't I represent all these people? They all seem to have the same interests. They're walking through the door and want to accomplish the same thing, and that is to form this entity. And sometimes you hear it described this way: can't I just represent the deal? In the sense that I'm trying to make this come together, so I'm just going to represent the deal. This raises the problems and pitfalls, as I described them in the outline, of joint representations. Right? If I'm going to try to represent all three and say that all three are my client, then would be a joint representation. The rules are very much, I don't want to say structured, but the rules of professional conduct are very conservative and pessimistic about joint representations in this context. Comment to Rule 1.7 identifies the specific special considerations in common representations. In considering whether to represent multiple clients in the same matter, the lawyer should be mindful that if the common representation fails because of the potentially adverse interests cannot be reconciled, the result can be additional cost, embarrassment, and recrimination. Ordinarily, the lawyer will be forced to withdraw from representing all of the clients if the common representation fails. And in some situations, the comment cautions, the risk of failure is so great that multiple representation is plainly impossible. So let's step back for a minute before we get to the risk. We have to consider what those different interests are that can arise. Consider the different interests here between the promoter, the person who wants to promote starting this entity, and the persons the promoter expects to participate in the business or in the transaction as co-owners, as officers, or whatever in the corporation, the entity to be formed. Some examples: issuance of shares. Is the promoter going to be issued shares? Employment of the promoter as an officer of the negotiation. negotiation of any agreement regarding relative decision-making power of one of the promoters and other participants in the governance of the corporation. So it's because of many of those fundamental interests are going to have to be negotiated, that in the context, such representations are disfavored, would be the best way to characterize it under Rule 1.7. Can you go to the next slide, please? And the additional factor that has to be considered is the effect on privilege and confidentiality among the joint clients. Comment 30 addresses this. With regard to the attorney-client privilege, the prevailing rule is that between commonly represented clients, the privilege does not attach. So it must be assumed in the room that if litigation eventuates between the client, the privilege won't protect any of the communications that they have with the lawyer present. And the clients must be so advised of that under the rules. Comment 31 goes on to explain that as to that duty of confidentiality, continued common representation will almost certainly be inadequate if one lawyer asks the lawyer not to disclose, if one client asks the lawyer not to disclose to one of the other clients information that's relevant to the common representation. And that's obviously because the lawyer has an equal duty of loyalty in that room to each client. Each client has the right to be informed of anything bearing on the representation that might affect that client's interests. And they have the right to expect the lawyer will use that information to the client's benefit. So the lawyer should, at the outset of the common representation and as a part of the process of obtaining each client's informed consent, advise each client that information will be shared and that the lawyer will have to withdraw if one client decides that some material matter, some fact or information material to the representation should be kept from the others. In limited circumstances, we can think of a situation where it may be appropriate to proceed with the representation when the clients have agreed, after having been properly informed about that the lawyer will keep certain information confidential. An example that's given in some of the literature, the lawyer may reasonably conclude that if one client has certain trade secrets they don't want to share with another client, but lawyer may conclude, that will not adversely affect the representation involving a joint venture between those clients, and that with proper disclosure, he or she could agree to keep certain trade secret information confidential with the informed consent of both clients. Again, assuming that trade secret information is not material to the formation of the specific joint venture that they're talking about setting up. But what's important, though, is that any limitations on the scope of that joint representation that are made necessary as a result of the common representation have to be fully explained to the clients at the outset of the representation, and preferably memorialized in a joint representation letter, which summarizes the pros and cons of the joint representation, all of the limitations that may exist regarding what the lawyer will and won't share, and what they will and won't do. All right, so we are at our first of our survey questions. If you can go to the next screen. So this is our first hypothetical. Joe Moneybags, Joe Moneybags and Jim Workingman. Joe owns 75% and Jim owns 25% of Success LLC, and a buyer is offered to buy their interest in the company. The proposed deal is that Moneybags, who owns 75% of the company, will receive 75% of the consideration from the deal, and Workingman, who owns the remaining 25%, will receive 25% of the consideration. Both parties will enter into non-compete agreements with the buyer, but neither will be involved in the business after closing. Attorney A has represented Moneybags for years and has also represented Success LLC on various transactions and litigation since it came into being. Moneybags and Working Man come to you, Attorney A, and ask you to represent both of them in the sale. Can you do so? So I'll give about a minute for people to make their selections in the poll. I've been told by the IP lawyers that I'm not allowed to use the Jeopardy music while we have these questions pending. So you can just do it along in your head if you would like. And don't forget, if you have requested CLE credit, you must respond to each of the polls to verify your attendance. So be sure to submit your response to the 3 polls, recorded polls that I have in this hour of the presentation. We'll give about another 10 seconds for a response. No? Okay, we've closed. We've gotten enough answers. 61% say yes, you can represent both Joe Moneybags and our Working Man, and 39% say no. Well, the answer here is yes. The interests of Moneybags and Working Man are generally aligned in this scenario. So you could represent both parties. You would have to get an engagement letter with joint representation language. But notice the elements here that make it possible is that they don't have any of those differing interests in terms of that would likely to come up in the negotiation. They've already agreed on the basic terms of the compensation. They're just going to get flat compensated as owners. There's no control discounts, none of the types of things that would differentiate between their interests. Let us go to the next hypothetical and survey number 2. Same facts as the previous hypothetical, except Moneybags will receive 90% of the cash paid at closing, and Working Man will receive 10% of the cash plus a 10% interest in Buyer LLC. Working Man will enter into a 5-year employment agreement with non-solicitation and non-competition provisions to be determined. Can you still represent both of them in the sale? The 3 options here are you have no conflict, so yes. No, you can't represent them. Or third, you have a conflict but can represent both of them with informed consent, waiving the conflict. So we have 30 seconds left, and don't forget to make your answer to receive your CLE credit. All right, I think we can close final 10 seconds according to Lauren, and then we'll close this one out. So yes, no, or yes with a waiver. We have 10% saying you have no conflict, so go on ahead, as in the answer to the previous hypothetical. We have almost 20% who say no, you can't represent both. We have just over 70% who say you have a conflict but can represent both of them with a waiver. I'd say the answer here is technically the third answer is correct, the one that 71% of you said. It's closer to a no, and you'd be well advised probably not to pass on the joint representation if possible. The reason here, you plainly have a conflict under Rule 1.7a. Your representation of Working Man in connection with the negotiation of the employment agreement and his or her ownership interest in the buying company could be adverse to your representation of Moneybags with the capital, the passive investor who has all the money with respect to the overall transaction. You can only then take this representation if you can satisfy the requirements of 1.7b of the rule, which means you reasonably believe that the representation of each client will not be materially affected by the conflict, and each client consents in writing to the representation after full disclosure of the existence, nature, implications, and possible adverse consequences of the common representation, including the possibility of having to withdraw from both, as well as the advantages involved, if any. In this instance, the waiver letter should explain the relationship between the parties, the implications, the pitfalls of joint representation, including an acknowledgement from Workingman that your work on his behalf could be impacted because of your relationship with Moneybags. So again, just because of some of these pitfalls and certainly some of the dangers that are discussed in comment 29 in the Virginia rules about that you should evaluate the risks of failure of the joint representation. This is one that could tarnish your representation of two clients if it does fail. And the closer you start to be concerned about those risks, the more inclined you should be to pass on the idea of a joint representation. So let's go to the third of our survey questions. Go to the next slide, please. Okay, Moneybags is the sole owner of the company and Workingman is the CFO. The purchase agreement says it is a condition to closing that Workingman enter into an employment agreement with the buyer with a non-competition agreement. Can you represent Workingman as well as Moneybags? All right, let's open up the survey. The same choices as the last one. You have no conflict, so yes, represent everybody. Option 2, no, you cannot represent both. Option 3, you have a conflict, but it could be waived by informed consent. And remember that you have to answer each of these questions to obtain your CLE credit. We have 30 seconds left. In this situation, a sole owner and a sole employee, but a condition is that the employee enter into a non-competition agreement. Assuming, of course, that they're permitted at that time. All right, we're about to close it up. Just a few seconds left. All right, we have more no answers, about the same number of yes answers. That is, you have no conflict and can represent both. We have many more no answers, 62%. And then we have fewer of the you can do it, but with a waiver. We have about 31%. I think this answer is closer, is pretty much a no. You could analyze it the same way with respect to the possibility of a waiver and what would be required. And there's certainly circumstances where you could know from the outset that the risk is very low regarding any negotiation issues that are going to come up in the employment agreement or the non-competition agreement for the working employee. But it's plain that your ability to represent the working man's interests are in conflict with your duties to Moneybags in connection with the acquisition. So plainly a conflict. Might try it with a waiver under circumstances that convince you that the risk is low and the benefit is high, and those are fully described and explained to the client. Now, I'm going to do one more that does not have a survey question because just in the interest of time and to get through the materials, but I'm going to add one layer on this hypothetical with the next slide. So here again, Moneybags is the sole owner of the company, but real estate owned by the company is owned by a partnership consisting of Moneybags and his brothers. It's a condition to closing the deal that the partnership enter into a lease with the buyer. Can you represent both Moneybags and the partnership, this partnership that owns the real estate consisting of Moneybags and his brothers? The answer here is for different interests involved, different potential parties involved, but same outcome. You would have to get a detailed waiver from Moneybags and the partnership in order to proceed with this representation because there plainly is a conflict. Now, note that this is not a joint representation. I talked about pitfalls of joint representation before, because Moneybags has no individual interest in the matter of the lease between the buyer and the partnership. You actually have two concurrent matters for two different clients in the same related to the same transaction, but they're not the same transaction. But it is a concurrent client conflict and possibly a material limitation conflict under Rule 1.7A2, for which the waiver rule that I described under 1.7B definitely applies. Now, I want to switch tracks a little bit. We've been talking about joint representation as one of the avenues available in this entity formation, who is the client question. Now I want to talk about single or one at a time representation. Can you go to the next slide, please? So there are really three possible structures if we go back to our original scenario of who we're representing in the birthday party company. One is that the lawyer will represent one of the entrepreneurs through the formation and organization of the company. The second is the lawyer will represent one of the entrepreneurs until the corporation is formed, at which time the corporation is capable of retaining its own lawyer. So these are sort of sequential ideas. I'll represent this person, and then once the entity is formed, I can represent entity and terminate my representation of the entrepreneur who hired me to do this work. The third option is that the lawyer represents this as yet unformed entity as an unincorporated association until the corporation is formed, and then the corporation formally retains the lawyer. Now, how can you do this? Let's focus more on the background here, which requires us to understand the representation of an organization as your client. And that's governed under Rule 1.13 of the model rules and, of course, as adopted in Virginia. Can you go to the next slide, please? So most jurisdictions, by the way, have not yet addressed this question of whether some form of entity representation is available before the business entity has been created. But it seems like that there is certainly an avenue for doing exactly that under the way that Rule 1.13 is structured. Rule 1.13 and its comment recognize that entity representation does not require formal incorporation. In 1.13a, a lawyer employed or retained by an organization, of course, represents the organization acting through its duly authorized constituents. And in the very first comment of the rule, it provides that the organizational client is a legal entity, and that it applies, and all of the duties defined in the comment apply equally to unincorporated associations. So you can represent an entity that's not incorporated, that doesn't have that formal stamp from the government, either as that formal registration. Arizona Ethics Opinion 02-06 that was issued in 2002 and is in the materials that I provided you, analyzes this issue, is one of the opinions analyzing this issue of whether some form of entity representation is available before that business entity has been created. The ethics opinion analyzes three rules: 1.6, confidentiality; 1.7, which is the general conflict rule; and 1.13, that we're looking at, the organization as client. And the Arizona ethics opinion reasons that because partnership and incorporation statutes permit ratification of actions prior to formalization of the entity, that the lawyer may represent the entity only if the forming constituents are notified and they ratify the pre-formation actions of the entity after it's formed. Now, interestingly, the opinion doesn't ever address who is the client in the event that the entity is not ultimately formed, that for whatever reason they don't go forward with it, the formal incorporation doesn't happen. The Arizona opinion really then goes on to detail how the lawyer should deal with those constituents. Once he or she has decided, I'm going to represent this as yet unformed entity. And it details how the lawyer should deal with those different constituents. Besides the requirement of notifying the constituents that they are not the client, very important, and obtaining the subsequent ratification of the pre-formation actions that the lawyer has taken. The opinion notes that all of the constituents should be warned that confidential information must be shared with the other constituents, though not with others outside of the organization. The opinion also indicates the lawyer should regularly remind the constituents that the organization is the client, and rather than each of the constituents individually, which is very important because in this, course of, just to keep it clear, this entity is not yet formed. You're dealing with these entrepreneurs who want to form it. They may ask questions. They're likely to ask questions, tax consequences, various things. So it's very important and helpful to continue to remind people, remember, I'm not your lawyer, I'm representing the entity. Now, can you go to the next screen, please? I mentioned how the Arizona ethics opinion has this quandary about and adopts an analysis of ratification of the pre-formalization steps. And there's kind of two models of thinking about this entity representation before it's formed: the retroactive and prospective models. You have some materials on this. I won't go into great depth on it, but just to talk about what they are, to identify them, and two authorities that, or some of the authorities that support the way of thinking about it. The retroactive is that where a person retains a lawyer for the purpose of organizing an entity, the lawyer's involvement was directly related to that incorporation, and that entity is eventually incorporated, that the entity rule in 1.13 applies retroactively. Right? So everything that the lawyer did pre-incorporation is deemed to be representation of the entity, not the person. The Arizona ethics opinion relies on that. No, you were representing, individuals, but it kind of prospectively, you're going to represent the entity. And as long as that is ratified by the entity, you can consider it that they were your client all along. It may not be much of a difference, but it's just two different ways of looking at who your client is before the formation actually occurs. The prospective form seems to also be supported by Rule 1.13a and Comment 1 that we discussed earlier, and it finds support in the Restatement Third of the Law Governing Lawyers. So those are two different ways of thinking about it. Now, can we go to the next slide, which is one more hypothetical, but without a survey, because I want to get through the material. So in this hypothetical, you've agreed to represent the as yet unformed entity that will be created by the magician, the baker, and the puppeteer to conduct birthday parties. You begin by discussing the possible alternatives for the entity to be formed, such as a limited partnership, an LLC, a corporation. In the course of these three consultations, the baker asks you, what is her potential liability under the entity alternatives? What are her individual tax implications? And what are her options if she decides she wants to withdraw from the entity? Can you answer these questions? And if so, how? Well, the practical issue in many situations is how the lawyer can avoid giving legal advice to constituents when forming an entity, right? I mean, how can they intelligently decide what entity to form without getting this information? It's part of adequate representation and adequate advice to the client of the consequences of different actions. In an Eighth Circuit case, Mannion versus Nagin, the court acknowledged that it was possible for a lawyer to represent only the entity, but noted that giving legal advice to a constituent as to their individual situation could create an attorney-client relationship between that individual and the lawyer. It may be difficult for a lawyer to repeat at all times necessary that she or he represents only the entity. And lawyers who rely on this model should understand the follow through that's necessary to make certain that they represent only the entity and that the other constituents don't end up forming an attorney-client relationship with the lawyer individually by reason of the things they ask and what the lawyer says. In this scenario, in my opinion, it should be possible to give generalized information as to all three of these issues. In other words, you could tell all of them, the baker, the magician, and the puppeteer, what are the potential liability of each of them as owners under those different alternatives. You can tell them what are the tax implications to individual owners. You can talk to them about options for withdrawal. So you can give that information to all three as representatives of the as yet unformed company, regarding those as advantages and disadvantages of the different entity structures. But you just have to keep repeating that you can't give them individual advice, and that you don't represent them individually, and that it may be appropriate for them to get individual counsel. Can we go to the next slide, please? There are other issues that you have to confront in this scenario, and I'm not going to go into great detail of each of these just due to time, although there's materials that address each of them in the written materials that you have. But they're worth flagging. Defining the scope of the representation at that outset. Is it going to only go through the formation and then the formation and organization of the entity, perhaps a little further to going into bylaws, buy-sell agreements, other things that can only be effectively done after formation happens? That should be defined. It should be defined if you're going to do an entity representation, what that scope is and where it ends. Remember that I talked about when they first come in the room, that you have ethical duties to all of them as prospective clients. And if the lawyer decided to represent just one, or that doesn't end the duties that you have under Rule 1.18 towards those you declined to represent. So you need to assess that as each of those people who came into that first meeting were prospective clients, and anything that they told you, you may have duties to keep confidential, even though you declined to represent them and represented one of the others. Ethical duties when dealing with non-client constituents in the formation of the entity on a client's behalf. We mentioned that there could be officers, potential employees, potential vendors or suppliers who could be involved or could be involved in discussions that everyone is having. I won't go into great detail, but there are duties that you sometimes have as to non-clients regarding what you say to them and what you can't say. A really interesting question is, does the status of the lawyer's client as a fiduciary itself alter the lawyer's duties in dealing with the beneficiaries of the client's fiduciary duties? And there's some interesting case laws in there in the materials regarding that issue. Most courts have held no, the lawyer's duties are solely those set out in the rules of professional conduct. But just as a caution, the restatement third asserts that a lawyer is subject to liability to a non-client when a non-lawyer would be in similar circumstances. And the last is about payment of fees by a non-client. We talked about the fact in this entity formation that you may have three people wanting to form it. You may end up representing one. You may subsequently be paid by the entity. All of those arrangements are probably fine, but there is Rule 1.8F that requires that if you are paid by anyone for your fee other than the client, that you have to comply with Rule 1.8F, which includes notice and agreement by the client to allow you to accept payment from a non-party. So let us go on to the next screen. just before we move on to the next short sections of today's training, 4 takeaways that are taken from a material that is in the materials that were handed out for today. 4 conflict of interest takeaways to keep in mind in this situation. The first one is that the first step in the multiple constituency representation, determine who is the client, right? Including, are you representing someone with a waiver? But most importantly, the first step is, who do I represent? Second, the attorney should avoid situations where loyalty to one party would put the attorney at odds with the interests of another. Third, the determination that the attorney makes should be communicated to everybody in writing so that everyone in the room knows who the lawyer represents and who they don't represent. And of course, joint representation language should be used if the lawyer agrees to represent multiple constituencies. And fourth, conflict waivers should be obtained that detail the conflict and the potential adverse consequences that could arise from waiving the conflict. Could arise from the conflict. All right. I'm going to move on really briefly to cover attorney-client privilege issues in mergers and acquisitions. Next slide quickly. So just to set the background here, the privilege here belongs, of course, to the represented entity, if you are the corporate lawyer. The organization is the client, speaking through its duly authorized constituents. Can you go to the next slide, please? So the issue here is, if you're going into a potential sale, merger, acquisition, whatever, a transaction that your client will be involved in, your organizational client, there's a lot of information that it's going to be exchanged during the due diligence process. How do you avoid waiver? I think most of us are familiar with the question of common interest. Can I protect privilege in a transactional context, or a possible transactional context, from waiver of the attorney-client privilege? If we share everything in due diligence, is there any way to protect it? And the concern here is that many courts require that to be a common legal interest to avoid waiver of the privilege by sharing with, let's say, the potential acquirer here, that many courts require it to be a non-adversarial and legal interest as opposed to a commercial interest. So it's not merely that, according to many courts, that we both share an interest in determining if we can do this merger. So an agreement in which a buyer does not assume the litigation liability of the seller, court may hold there's no alignment of their legal interests. A sale of assets or a potential merger as opposed to an acquisition may not suffice to constitute that non-adversarial and legal interest. There are cases where disclosure to the corporation's investment banking firm during the merger discussion have been held. They have no common interest and the privilege can be waived. The Egan and Whitlock materials suggest that there's a higher probability that information will remain protected in the transaction that actually closes, and in which the buyer assumes liability for the seller's litigation, than in a transaction that doesn't close for whatever reason, and in which the buyer does not assume liability for the seller's litigation. I think that's true. One interesting approach to this is, and many of you are no doubt familiar with using these, are privilege not waived clauses in the governing document, and that attempt to state the common interest, define a common interest, and assert that the parties are not waiving it by disclosing confidential information in the due diligence process. And I cite one from the ABA's Model Asset Purchase Agreement in 2001. So you can attempt, but as I say, depending on circumstances, jurisdictions, The concern is whether the court will find under those circumstances a common legal interest to support non-waiver under the common interest doctrine. Can we go to the next slide, please? Post-acquisition, who owns the privilege? It's to boil it down to simplify it. In a statutory merger, the surviving corporation owns the privilege. In a stock-for-stock deal, the surviving corporation, although the buyer and seller may, in their agreement, reach an agreement to share privilege. Some things have to do with what the buyer or what the seller controls because it pertains to seller liabilities, potentially or seller involvements, and then buyer retains the rest. Asset sales, kind of mixed results in the courts as to who owns the privilege post-acquisition. Best advice is to try to anticipate this and address it in the sale documents itself. I cite some examples here from different cases. And I don't have time to go into great detail about those, but there is some information about each of those cases in the course materials. Can you go to the next slide, please? Really briefly here, I'm going to talk about the duties of candor in this context. I mentioned in one of the earlier slides on formation and sale that you have some duties to non-parties and non-client constituents. And the question sometimes comes up about must the seller's buyer always be truthful in dealings with the buyer? The framework for this is Rule 4.1 of the Rules of Professional Conduct, truthfulness in statements to others. And that's very simple. In the course of representing a client, a lawyer shall not knowingly make a false statement of fact or law, or fail to disclose a fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client. Can you go to the next slide after that? The next one, sorry. Oh, actually, if you can go back one minute to the prior slide. A couple of things worth knowing here and appreciating this wherever you see the word knowing or knows by the lawyer in the rules of professional conduct. And that is that knowingly and known, all variations of that, it is defined in the preambles of the Virginia Rules of Professional Conduct to denote actual knowledge of the fact in question. Although a person's knowledge may be inferred from circumstances. So it doesn't have to be direct evidence of that the lawyer was told something, can be circumstantial. But we are talking about actual knowledge, not just that the lawyer should have known that a statement that you passed on from your client was false. It is actual knowledge as the standard. I'm sorry, can you now go on to the next slide? I'm just going to do one of these hypotheticals. Well, actually, I have time for a few of these to demonstrate how the rules would apply in the context of statements made during due diligence. Your seller client has posted all of their material contracts in an electronic data room. The buyer has placed a high value on the contracts. One of the contracts may be terminated by either party with 30 days prior notice. Your client is worried that the buyer will read that contract and either seek a purchase price reduction or terminate the deal. Now, the buyer's been given full access to the data room and has completed due diligence, but says nothing about the 30-day provision. Do you, as an attorney, have a duty to affirmatively draw the other side's attention to the provision? Well, the answer here is no. Under Rule 4.1, the attorney has no duty to tell the other side about relevant facts. If asked, the lawyer cannot lie, but there's no duty to make the other side aware of contractual provisions, assuming the contract has been made available. Since the client's not committing any form of fraud here, the provision was made available for everyone to see, that's not a failure to disclose a material fact. Now, can we go to the next slide? Seller tells her client she will not accept less than $100 million for her business. The attorney then tells the opposing client that the client will not accept less than $125 million. Did the attorney violate her duty of candor here? And the answer is no. And the reason is that this should generally be considered puffery. This is the kind of thing that people expect, in a sense, that the lawyer is going to try to get the best deal for the client. And so the best answer here is no, this is not a clear misstatement. Everyone knows that, that lawyers are trying to get the best deal for their clients. Now, go to the next hypothetical. The seller client has marketed her business for months with the help of her attorney and only received one offer from a potential purchaser. In the course of negotiations, the attorney tells opposing counsel, your client needs to act quickly. We have multiple offers on the table for this business. Now, did this attorney violate his duty of candor? The answer here is yes, because it is a simple factual statement, not one of opinion, not one of prediction, as the previous one was. It's just a factually false statement. I'll try to get through one or two more. I can't see if we have questions at the bottom of the screen. We have one, so I'll try to read one more of these and then look at the question. So same facts, but there was one other person who expressed interest in the business. The attorney tells opposing counsel, other people have shown interest in the business, so your client needs to act quickly in agreeing to a contract. Problem here? I think that this statement is probably permissible, again, as puffery, and it's vague as to other people. I mean, there's at least one other person. It may be an exaggeration of the interest, but there is some basis in truth for the statement. Now, if I can, I'm going to see if there are questions here. I'm going to go back to a question from the section on conflict. And the question is this: is it possible to force the parties to come to an accord as a precondition to representation to ease that risk of conflict, agreeing in time, duration, scope of the non-compete, or using an industry standard? So I think this question refers back to that hypothetical in the survey where we were concerned about a joint representation, where one of the conditions of the deal was going to be that one of the represented clients who was an employee was going to be required to enter into a non-compete and an employment agreement. Remember, and we analyzed, well, there's different interests that person has as opposed to the passive capital potential client. And so I think the question here is it possible to, although it says force the parties to come to an accord as a precondition to the representation? I mean, not to force, and as a matter of fact, that would be that would be improper. But I think it puts an important aspect on it. That is, if the parties themselves have agreed to the issues that were more likely to create differing interests, conflicting interests between them. If they've already agreed on some of those issues, and really all that's left to do is to draft it and negotiate what would be uncontroversial aspects of a non-compete. That can be embodied, that can be memorialized in the joint representation agreement, and could make you more comfortable in going forward with the joint representation and waivers, right? Because it lowers the risk of failure of the joint representation, that they might, reach that. It also lowers just the conflict, because if the employer, if that employee comes and tells you at the very first meeting, hey, they are going to require me to enter into an employment agreement and a non-compete, but there's really nothing to negotiate there. I already talked to the president of NewCo. He and I already have agreed. I love the company. I want to go work for him. We basically already agreed on a standard terms of agreement. There's nothing to negotiate. He wants me to sign a non-compete for 3 years in Virginia, and that's no problem. I'll sign it. Well, that might be circumstances that at least allow you to do the joint representation and do it comfortably. So my time is up now, and I am going to, oh, I'm sorry. I do want to remind you that if you asked a question Well, not if you asked a question I didn't answer, since I think I answered the only pending question. But if you have a question, reach out to me and I'd be glad to speak with you.